Thank you.
Mr. President, distinguished members of the court, as a legal professional who was dismissed from public duty by an emergency decree, like the applicant, it's a profound honor to appear before the Grand Chamber today. I will address first the administrative practice and second the government allegation of misleading. As a practicing lawyer in Turkey, I am closely familiar with the practical difficulties faced by detainees in situations comparable to that of the applicant. While the government has made submissions regarding current practice, my own experience, shared by colleagues across the country, reflects a different picture. If the court would be assisted by this, we will seek to obtain documentary evidence. Although the legislation contains no explicit prohibition on receiving photocopies or internet printouts, the practice in reality is unpredictable. On several occasions, the applicant and his cellmates received internet-based materials. On other occasions, similar documents were withheld. Whether such materials were delivered depended largely on the discretionary assessment of prison officials. In the absence of any consistent or foreseeable standard, as Turkish lawyers, we frequently exchange experiences with colleagues across the country. Many observe a distinct lack of uniformity in administrative practice in this area. Turkish lawyers observed that legal expert opinions, particularly those concerning biolog data, have in practice been refused delivery to inmates simply because they were internet printouts without any assessment of their actual content. Consequently, the practice is in effect arbitrary. As the applicant and similarly situated inmates face severe violations in their criminal proceedings and remain behind bars for many years, they often feel exhausted and fear pursuing legal remedies against such restrictions. In order to avoid exposing themselves to further administrative pressure within the prison environment, I would also address the government's allegation that the applicant's statements were misleading. That is incorrect. The applicant never saw the attachments to the second letter. Notably, the government did not submit copies of these letters at the chamber stage. The applicant accessed their contents only before the Grand Chamber. The applicant's statements reflected his reasonable understanding at the time. He presented all documents in his possession, pursued remedies, at times without legal assistance, and acted throughout in good faith and with full transparency. Finally, the withholding had a chilling effect. After 2 letters were seized, his family understandably refrained from sending further educational or medical materials. At a time when the applicant was injured, in pain, and preparing for examinations that would shape his prospects after release, he was deprived of external assistance, including communication with a sister, a qualified physiotherapist. I now give the floor to my colleague, Mr. Tinsley. Thank you for your attention.
Thank you.